Welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on June 6th, 2024, which means in 2 days, the eyes of the nation will be focused on That's right. That is The Sidewalks of New York, which was the original official song for the Belmont Stakes, which will be run outside of New York City in a couple days. So if you are into horse racing, just for the pure love of the sport, or, maybe for making a little money, a few bucks, placing a few bets, this is the podcast to listen to. So we have IJ's own Kentuckian, Brian Morris, back on the show. Now, a couple years ago, we had Brian on to talk about the Kentucky Derby. We've unfortunately not been able to put that together the last couple times that the Derby has run. But conveniently this year, we had a case come out just a couple days before the Kentucky Derby about the Kentucky Derby and betting. So we have Brian and his horse sense back to talk about the last leg of the Triple Crown, that being the Belmont Stakes, and in time for the running. And also we're going to be talking about the Sixth Circuit case that involves gambling and the Kentucky Derby. So you will want to stay tuned for those numbers in just a moment. Brian, he tells me he never fails with his predictions. So after that, we're going to go to someone who also has a lot of horse sense, and that's Mike Greenberg of IJ. And Mike will talk about a rather different subject, the Fourth Amendment, search and seizure, and human trafficking from the Fifth Circuit. So first of all, let's bring Mike on. And Mike, so you were telling me you have not been to a Triple Crown race, but you have been to some horse racing.
I have. There's a horse track near my hometown in South Florida, but I have never been to one of the major ones, and I don't know. It's not really my super duper my thing. I am happy, I will say, that this week's horse coverage on Short Circuit is of the slightly more traditional horse related activities after last week's horse related digression. But no, that's not the answer to the question.
Yeah, that was you talking about Sam Gedge bringing up the case about horses and slander that listeners can go back and listen to. And we will. This is a family friendly podcast. We talk about gambling here, not not blue language. So we're not going to go back there. But listeners can, if the parental advisory they take that, they can go back and listen to it. So now on to Brian. So we of course do not have a chance for a Triple Crown winner this year because the Kentucky Derby winner just lost by a nose at the Preakness. But nevertheless, they're both running, both those horses and many others. I see the odds 48 hours ahead of time. I'm sure they're going to change. But your reading of that, what do you think?
Yeah, it's interesting. So the Belmont's this Saturday. It's like you said, it's the last leg of the Triple Crown. Some say it's the hardest thing to accomplish in sports. It's much more difficult than what Mike cares about, the Yankees winning the World Series. So for listeners who aren't familiar, there's 3 races in a month, and they're all different lengths. And this year, to correct you on one point, Anthony, the race is not at Belmont Park this year. It is under remodeling. So the first time since the 60s, it's being run at Saratoga Park.
I am completely out of touch.
Yes.
And the good thing I'm not giving the prediction.
It's actually a huge deal for bettors because typically the Belmont is the longest race at 1.5 miles. This year, because Saratoga is a smaller park, it's only 1.25 miles. So that's the same.
Oh, wow.
Yeah,
same as the Derby. You were
correct. That's the same length as the Derby. So that's a big deal because if listeners saw, or if they haven't, they should go back and look. The Derby was one of the closest finishes I've ever seen. I mean, it was like a 3-way photo finish, and if they had run for another 10 feet, the results would have been very different.
Yeah. Yeah. So did I have that wrong that the by the nose was the Derby, not the Preakness this year?
Correct. Yeah, the Preakness, Mystic Dan came in second, but it was not as close as the Derby. The Derby was
super
duper close. It was it took 4 or 5 minutes to even figure out, what place everyone was in.
Right. So win, place, and show.
Yes.
What do we got?
The smart money is probably on the odds-on favorite, which is Sierra Leone, the horse, not the country. It came in second at the Derby in that wild photo finish. And again, like if the Derby was any longer, Sierra Leone wins that race. And what's important is he actually skipped the Preakness, so he is all rested, unlike Seize the Gray, who won the Preakness, and Mystic Dan, who won the Derby. They're both running their third race in a month, so there's a reason Sierra Leone's a favorite. You could say the same there's a horse called Resilience, which is 10-1, I think, when I checked, so pretty good return on your money. He was down the stretch in the Derby but faded, and he's rested now, so could be a good one to bet on. But for better or worse, I never bet on the favorite. It's just not where the money is. And my wife says every year, she goes, maybe you shouldn't bet on all the long shots because you never win. But I like Seize the Gray because he won the Preakness, but he's in the one post, which I don't love. But the Belmont looks like it could be muddy, which was the Preakness was muddy, and he won wire to wire. So I usually like to bet with my emotions, which is a whole nother conversation that we can have. But for those who aren't familiar with horse betting, I like to bet, which is called a try box. Anthony, are you familiar with that?
Try box? No, do tell.
So a try box is you pick the top 3 horses, but they can finish in any order. So you basically you're boxing the 3 numbers of the horses, and they can finish in any order, and you're paying for the different combinations. So you could pick 3 horses. I'd probably I'd stick with Mystic Dan. He finished first in the Derby, second in the Preakness, and I think maybe he'll finish third in the Belmont. Give it a little 1, 2, 3. You could put Sierra Leone in there. And then I really like a horse named Dornock. That's my long shot. I always like to put a long shot in there because then you get the payouts. And it's 15-1, but the trainer is this guy named Danny Gargan. Not a huge name, but he's a fellow Kentucky native who grew up 5 blocks from Churchill Downs. His dad was a jockey. He's a Louisville guy, so kind of hoping for him to win his first big race.
Absolutely.
Yeah. So, but, this is, I guess, the full disclaimer is I have equal success letting my 5-year-old pick the name. So take it or leave it however you want.
So what's the payoff then if it so that's kind of like picking a horse the place, right, in the top 3, but you're picking the 3 in the 3, but it doesn't matter. So like say you put in $10, how does that, is it like they mix all the odds together, or how does that work?
Yeah, so you pay for all the different possibilities, but then really your winning ticket is just as if you bet on that one specific order, 1, 2, 3. So the odds will change depending on what order the horses come in. So if you have the long shot come in first, and then maybe the favorite come in third, and you hit, that's going to be a bigger payout because less people will have picked. You're basically, in horse racing, you're not betting against the house, as the opinion that we're going to get into talks about. You're betting against other bettors. So the long shots are people that the other fans think aren't going to win. And so you're smarter than them, and you pick the long shot that they didn't pick. So the longer odds that come in at the top of the ticket, the bigger the payout. So they can be, and then also the bigger pool of money for a particular race, the more money that you get paid out as well.
So let's get to that case. And this is, I did not know the terminology, pari mutuel wagers, where you're actually betting against other people who are betting, although the house takes a little cut. So let's get to this. Matura versus Baffert?
Yes, Baffert, Bob Baffert, which for listeners who aren't familiar with him, he's the most decorated horse trainer ever. He won 6 derbies, 7 if this case didn't exist, I suppose. And he's won 2 Triple Crowns. But he's also basically a movie villain. He looks like a Bond villain. He's rich. He's got long white hair. He wears sunglasses. And as this case shows, he also has a bad habit of giving horses performance-enhancing drugs. So, which I guess there's no Bob Baffert horses in Belmont, which is interesting. I think his ban in New York, he was banned from the Belmont for a while. I think it's over.
Yeah. We actually, I think, talked about a case involving that a few months ago in the Ninth Circuit, tangentially related to some of those issues.
Yeah, he's also still banned from racing in Kentucky, so he did not have any horses in the Derby. He had a couple in the Preakness, but Baltimore, I think, lets anybody race. So, and
it's like Amsterdam.
If listeners want to have a Baffert related pick, they could pick. There's a horse called Antiquarian, which is I think at 12-1 right now. But the jockey's John Velasquez, who was the jockey who rode Medina Spirit, which is this case all about in the Derby. So,
by the way, I should point out. So the case we did a few months ago, where our colleague Christian presented the case, was Jerry Jamgacholian versus Ferraro from the Ninth Circuit, and it was about a racehorse called Malpractice Muser. So different cast of characters, I think, but some of the similar issues.
Yeah, I mean, horse names are great. I mean, you could have a lot of horse names named after legal concepts for sure. So Bob Baffert, so he also has the 2 horses. He was the trainer for the 2 horses that won the Triple Crown since the 1978 winner, Affirmed. And so this case is about the 2021 Derby, and Bob Baffert had a horse called Medina Spirit that finished first in the Derby. So there's another horse, Mandolin, who finished second. Hot Rod Charlie finished third, and essentially Quality fourth, which we were just talking about. I love horse names. There's one horse in this Derby was called Soup and Sandwich. But 9 months after the race, Medina Spirit is disqualified because it tested positive for performance-enhancing drugs. So, like we talked about, Baffert has become notorious for this, and all the prize money, millions of dollars, are reallocated between the winners. But what this case is about, the bets were not affected. So you have the plaintiffs in this case is a group of bettors who, if, like we were talking about, if Medina Spirit had not finished in the top 4, they would have won. So these are everybody who would have won if this horse just would have come in at the back of the pack. And then they sue Baffert and then also Churchill Downs, and under a variety of theories on why they should have won. And the Sixth Circuit, interesting enough, it's a great place for this since it is located in Kentucky. It gets all of these Derby-related lawsuits. There was one in 2019 that was really interesting, where Maximum Security was the winner, but he was different than Baffert's horse. He was DQ'd on the day of the race because of an interference call. The horse had swung out into the middle of the track and impeded other horses. And then those owners sued the Derby trying to declare the ruling wrong. And that made its way up into the Sixth Circuit. So these races, obviously, a lot of money on the line, both for the horses and for bettors. And here they brought negligence and unjust enrichment claims in state court, and the defendants removed them to federal district court, which is interesting for our listeners who are into Fed courts issues. It was removed under the Class Action Fairness Act, which is CAFRA for short. And this allows the removal of large class actions from state courts to federal court. And one of the things it does is typically to have what's called diversity jurisdiction, you need everybody who's a plaintiff has to be from different states as the defendant. So if you have a plaintiff from Kentucky, but then also one of the defendants from Kentucky, that is not complete diversity, and you cannot go to federal court. What CAFRA does is it relaxes the diversity requirements to require only minimal diversity. So it just means, kind of turns it on its head, where to get into federal court, you just need one plaintiff to be different from one defendant. And as long as there's some difference, so everyone's not from the same place, then you can remove it to federal court if it's a class action that is worth over $5 million. And that's the other kind of nerdy thing too, is typically for the amount in controversy for a diversity jurisdiction, you need one plaintiff's claims to be worth, like the amount in controversy has to be over $75K for one particular plaintiff. Here, what it does is all of the damages, the amount in controversy for all the plaintiffs collectively together has to be $5 million. So it's kind of a unique way to get into federal court. More class actions end up in federal court that way. And
which also means that the betting here, they're alleging, was pretty substantial.
Yes, there's a lot of money on the line in these Triple Crown races. So they file this claim, this class action. It's removed to district court, and the district court grants the motion to dismiss. So one of the reasons it was dismissed is because for the negligence claims, it applies, with the diversity jurisdiction, you typically are applying state law, and here you're applying Kentucky law about horse racing and these pari-mutuel wagers, which, as we talked about, in horse racing, you're betting against other bettors, not the house. So there's a pool of winnings. And if you make a bet that other bettors don't, then you get more money. And if you win, but everybody else agrees with your bet, you make not very much money, right? So Kentucky has a rule of finality with horse racing that says the first official finish dictates the winnings, and that's it. So later disqualifications that happened here, they just don't matter under Kentucky law. So one of the lines I like in this opinion, it says, so the disqualification of Medina Spirit, quote, may affect the purse in the history books, but it doesn't affect the bets. So the Sixth Circuit affirms the dismissal and then kind of brushes away the same unjust enrichment and the other claims as well, all for the same way of, well, there's really no injury here because under Kentucky law, they don't win because of the finality rule. But there is also a claim under a negligence per se theory, which I think is super interesting. So just as a reminder, negligence per se is when a defendant violates a statute or a regulation without an excuse. So they're automatically considered to have breached their duty of care. And they're negligent as a matter of law rather than kind of having to go through the different elements. And the theory here is that Baffert, by drugging his horses, has violated these administrative regulations about trainers protecting their horses, so he's automatically negligent. Now, the court says there's no injury again for the same reason. They've already lost the bets, and under Kentucky law, they don't win the bets anyways. But I think the court makes an interesting comment where it says, even if the disqualification or Baffert's negligence, the negligence per se, could turn these losing bets into winning bets, they still don't have, there's no causation for an injury because the plaintiffs would have benefited from the negligence rather than harmed by the negligence, right? It was Baffert's negligence that gave them the winning tickets because the horse got disqualified. Had Baffert not been negligent, Medina Spirit would have won. It wouldn't have been DQ'd, and these people would just have losing tickets.
What isn't part? So I was very confused by that. But isn't part of their argument that it wouldn't have had the drugs, so it wouldn't even come close?
I suppose, yeah. It's a complicated theory. There's a reason why this gets dismissed, but it is interesting to think. They're complaining about drugging the horses, but they benefited from the disqualification. So it's an interesting issue. But the moral of the story, I think, at the end of the day, is at least when betting on the Derby, the official order on race day that matters. So cash your tickets in, and you don't have to worry about later disqualifications.
So a takeaway that I had that was entirely unrelated to the merits, and I have one takeaway that is related to the merits, but I did not notice until reading this opinion that Kentucky's state court cases are in the Southwestern Reporter, we need like conference realignment for the regional reporter system, because that doesn't make any sense to me.
It's SEC territory, baby.
Exactly. Yeah. This is, it should be, I suppose there is there is an SE reporter, right? A Southeastern reporter. So I don't know what's up with that.
I have long thought that about, I'm glad you said something, Mike, because I have long thought that, yes, a lot of these reporters are very, like, isn't Oklahoma is like in the Pacific reporter, I think.
That sounds vaguely familiar too.
Yeah. But, they're based on, it's like I'm in Minnesota in the old Northwest.
Yeah.
Kind of thing.
Need like a 21st century, conference realignment. But yeah, the negligence theory just kind of struck me oddly. Like, it almost seems like the plaintiff should have made like some kind of claim about the regulation itself being wrong or silly or not proper, because I don't know why. Like, you sue Churchill Downs, the track, saying, pay me my money, they would invoke the regulation as a defense, and then you can respond having also sued the horse track. Oh, but that's a stupid regulation. It's irrational, whatever the claim is. So it's no defense at all, and they should have to pay me. Maybe that's not a winning claim on the merits, but the negligence claim wasn't a winning claim on the merits either. So I don't know. The whole thing seemed a little convoluted to me.
I don't know. Maybe our next economic liberty case can be attacking the facial challenge of some Kentucky horse racing statutes.
I'm not going to hold my breath on that one.
What I didn't get from we were talking about this before we started recording. What I didn't get from the case is they also they complained about this money they could have made in Vegas betting there, but because the Vegas people shouldn't have had the horse that able to bet on because of the drugs, but which doesn't make sense in itself. But also they didn't sue the people in Vegas, and so the court's kind of like, why are you even talking about this? So, sometimes these class actions are pieced together and maybe not everything is thought through, and you get a settlement anyway. We have talked about that recently involving some other litigation, but maybe this was another example of that. By the way, I looked up it wasn't a couple years ago, it was last year. We actually talked a little bit about Kentucky Derby with Brian, and Mike was on that episode as well. So we will put a link in the show notes to that. But in terms of this case, it seems like really this is a case of the law likes having finality. Whether you like it or not, gambling is regulated, and so the state just wants a cutoff point, and the courts are happy to go with that. I mean, there was no constitutional claim here that this is an irrational restriction on contract or whatever. And I mean, it seems like the Churchill Downs is very happy with this rule and would probably have it as a private rule anyway, because they don't want people coming, years later and asking to rearrange all the money. Although it must be said, they did do that for the actual winners, as you would expect them to do.
Yeah, this whole thing would make a lot more sense if Churchill Downs hadn't paid anybody and used the DQ as a reason for that, but that's not what happened here. So.
Yeah. Well, and of course there's a lot of process in these things, and we hear about these Olympians who lose their medals years later. I think the case is up. So
yeah, I know
it is what it is.
Yeah, I think Churchill Downs is, I would support a rule that says we're allowed to take money away from Bob Baffert and nobody else. So
yeah, well, you might have some other constitutional problems with that one. There perhaps were some constitutional problems during a stop near the southern border. So, Mike, walk us through that one.
Yeah, so this case also might be described as involving animals that perform beyond what can reasonably be ascribed to their natural state, at least in my view. It might also be yet another case of bad Fourth Amendment facts making bad Fourth Amendment law. This case involves a gentleman named Martinez who arrived at the Border Patrol checkpoint in I'm going to mispronounce the name of this town in Texas, Falfurrias, Texas. He was driving a tractor trailer. And at the checkpoint, it's well established that agents can ask questions about your immigration status, basic border checkpoint stuff. And if there's reasonable suspicion, they can refer you to what they call the, quote, secondary inspection area to gather more suspicion that you're violating some law. And then if there's probable cause, they can search the vehicle that you're crossing in. A quick aside about this checkpoint, it's not actually at the border with Mexico. It's 75 miles north of the border, pretty deep into the mainland of Texas. So apparently everything that comes after what I'm about to say, if Mr. Martinez had just kind of stopped at the first town he got to in the U.S., none of this happens. And the Border Patrol is apparently less concerned with it. I don't know. It's fascinating that we're like 75 miles north of the border and we're still calling it the border.
Well, border zone rules are different, right? And
exactly.
Border zone is a lot more than the border.
Yeah, it's I believe it's 100 miles beyond the border, but we still call it a border checkpoint. Anyway, as Martinez is kind of driving his truck through the lane before he gets to the little like question asking window, there's an agent and a police dog that are sniffing around his truck as it's approaching the window. And the police canine, according to the officer, alerts to the cab of the truck by putting its paws on the cab and then sitting down. That's apparently his alert. And so based on that, the canine officer tells the question-asking officer to send Mr. Rodriguez over to the secondary inspection area. And at the secondary inspection area, they ask Mr. Martinez to step out of the cab, and then they ask him if there's anyone else in the cab, and he replies no. And so they run the dog on the cab one more time. The dog alerts, and that alert, the officers say, is probable cause to search the cab of the truck. And so they search, and in the sleeper compartment, they find several undocumented immigrants kind of stuffed in there, being, to use an ungenerous term, smuggled. Not great all around. Among the many other things going on here, I'm sure transporting an undocumented immigrant is a federal crime. And so Mr. Martinez is charged with that crime. And he's going to plead guilty, but conditioned on his suppression motion to suppress the search of the cab as fruit of the poisonous tree under the Fourth Amendment. Here's his argument. There's kind of varying stages to it. The Supreme Court has held that a sniff by a dog alone is not a search. But to extend a traffic stop beyond its original lawful purpose, or to prolong it, as the courts say, you need reasonable suspicion of something beyond what the initial basis for the stop was. And here the initial basis for the stop was just to ask very basic immigration-related questions. So Martinez argues that the original dog sniff alone was not sufficient reasonable suspicion to send him over to the secondary inspection area. And so everything that came after that violates his Fourth Amendment rights. Here's the critical fact. When we think of police dogs, we think of dogs that are trained to sniff for drugs, maybe explosives, but it's almost always drugs. And the Supreme Court held in a case called Florida versus Harris that evidence that a drug dog is certified by some objective training agency to sniff for drugs is a pretty good evidence that its alert is probable cause to search the car for drugs. But this dog is trained to sniff not just for drugs, but also for, quote, concealed humans, end quote. As a factual matter, I'm very confused about how a dog can alert to the fact that a human is concealed. Mr. Martinez says we can't possibly know whether the dog is alerting to the scent of like literally any human or someone who is concealed, whether it's the driver or a fully legal person who's sleeping in the cab, or as here, someone who is not allowed to lawfully be present in the country. It's just the dog sniffing for a person. The dog can't tell whether the person has proper immigration paperwork or anything like that. It's just the scent of a person. The dog can be well trained to alert what it's trained to alert to. But if what the dog is trained to alert to could be perfectly legal, the scent of the driver, the scent of someone who's lawfully present in the country, who's just hanging out in the back of the cab, then it can't be reasonable suspicion of any contraband or any illegal activity. It's as if you have a dog that's trained to sniff for both illegal drugs and Advil or something like that. If it's just as likely that the dog is alerting to Advil, which is perfectly legal, that can't be reasonable suspicion. Here's what the Fifth Circuit says. It says that none of that matters. Because the dog was also trained to alert to illegal drugs, in addition to, quote, concealed humans, it was reasonable for the officers to think that the dog's alert indicated that there were drugs concealed in the cab, and that's all they needed for all this to go down. It didn't matter that they didn't seem to actually be interested in drugs, or that the initial sniff couldn't tell them whether there was exactly what kind of person or whether that person was lawfully present in the country. It didn't matter that the sniff could have been perfectly legal based on what the dog is trained to alert to, because it also could have been drugs. That is enough for this search to not violate the Fourth Amendment, or at least for the initial stop to continue on lawfully. I'll confess I am not convinced. I think the fact that the dog is trained to alert to things that are perfectly legal and to things that are not legal is not a basis to conclude that the sniff or the alert was obviously the illegal stuff. But the Fifth Circuit unanimously disagreed with me. So unfortunately, Mr. Martinez his guilty plea stands, and the seizure and search are lawful.
I'll go a step further, Mike. I don't care what the dog's trained to alert to. Dogs are junk science. I mean, to me, it's the same as like a lie detector test. There's just no evidentiary value. Where, as this case talks about, to me, like the alert is sitting, right? That's it. That's something the dog does all the time. And guess what? If it sits, it gets a reward. Wow.
I was just going to say, the opinion says that the dog, after alerting, gets a toy. And so, like, the incentives here, well, one, that's a kind of very silly thing for a federal judge to have to write. Like, oh, the police officer did good work, so he gets a toy, right? Like, but yeah, the incentives are such that this should be sort of taken with a grain of salt at an absolute minimum, I think.
But he has a certificate from Canine University showing he's an expert in the field. I mean, that's basically what the Supreme Court has said, that all the reasoning you need.
Yeah, I mean, this opinion doesn't get into it, but it's pretty well established in the literature that a lot of these certifying or dog certifying agencies are, former police officers. It's kind of a cottage industry of former police officers who then go out to help former police or current police officers in getting their dogs certified. And the opinion itself in saying that the dog was reliable in searching for drugs, the opinion cites two cases where previous dog sniffs were found to be probable cause because the dog was trained to sniff for 4 or 5 different types of narcotics. Oh, and the dog didn't find any of those narcotics, but it was trained to find certain narcotics, so that's good enough. That's the precedent that this opinion is relying on, basically conceding that dog sniffs are often not reliable indicators of probable cause. But yet here we are.
Yeah, it's for people interested in the dog sniffing issue. We will put a link in the show notes to an interview we did a couple years ago of a couple Australian authors of a great book called Guilty Pigs, which is all about how the law interacts with animals. And they have a chapter in there about we talked about on the show about this issue and dog sniffs, and that extremely unsatisfactory case that IJ wrote an amicus brief in that you mentioned, Mike, where Justice Kagan, I mean, I think it was unanimous, just said, well, these dogs are trained and we rely upon them. And why would they alert if there were no drugs? I mean, it's silly. I mean, this actually came up at oral argument. Justice Scalia asked, I don't get it. Why do you care about a false alert? Then nothing bad's going to happen. It's like, are you listening to yourself? And of course, the biggest answer often is forfeiture, because they're going to find legal cash and take it away, and that's something our audience knows a lot about if you've been listening to Short Circuit. But here we have the different illegal things, which kind of makes the issue even worse, even though the people with the illegal things, of course, are guilty. But if you have a dog alerting to drugs that aren't there, but, you found something else that's bad, I don't know, some either undocumented people, or it could be all kinds of, other issues. It could be firearms and they're a felon. Of course, that comes up a lot. Or it's, some non-prescription Adderall, which of course a dog is not going to alert to, but could be found. So there's a whole kettle of issues there that just, I'm just dumbfounded by how naive the Supreme Court was in that Harris case.
Yeah, and I mean, in other contexts, the Supreme Court has kind of gone out of its way to say when something that is the basis for reasonable suspicion would apply to, basically far too many innocent people in the population, that can't be reasonable suspicion. You have to kind of discount some, fully plausible legal rationales for what could be going on. And the Fifth Circuit here doesn't really seem to be doing that. And this is an issue that's arising in plenty of other contexts as well. At oral argument in this case, the counsel for Mr. Martinez noted that a lot of state courts right now are grappling with as marijuana gets legalized, generally speaking, in a lot of states, but it still has some illegal applications, basically, right? Like you can't be smoking in a car, or you can't be smoking in public, or it has to be containerized in a certain way. Does the odor of that legal product amount to reasonable suspicion or probable cause? IJ just filed a couple of amicus briefs in a few cases raising exactly that question. And it's an issue that the courts are struggling with, and the Fifth Circuit seemed to struggle with here as well.
And we'll also put a link up to at least one of those briefs, so interested listeners can check that out. But yeah, there is a lot coming together here, and I would be hopeful that the Supreme Court eventually revisits this issue. Maybe it's because of the semi-legalization of marijuana in different places, and maybe it's just because it was just such junk science to begin with. But of course, the police lobby, the police dog lobby, I should say, although not by the actual dogs, is pretty strong and pretty numerous, and so that will be a fight for years to come, I bet.
Yeah, I would love to see the Supreme Court finally take another Fourth Amendment case.
Yeah, that would just be nice in the abstract. The Fourth Amendment, it hasn't taken one for several years now, and the clock is ticking. We'll see. Maybe that'll change. That could change any day. But as of this recording, they have not taken a Fourth Amendment case in like 2 or 3 terms, I think. Mm-hmm. Well, thank you both for this. It turns out to be an animal episode. So horses, dogs, we got you covered. Maybe we'll look for some other of nature's creatures for the next show. But in the meantime, Thank you for coming on, gentlemen. Thank you for listening, everybody. And I ask that everybody first place your bets, and hopefully you're going to be happy because of Brian's wisdom. And otherwise, I want all of you to get engaged.